God is with these two beautiful souls, and I have no doubt that they are at peace. I had my last faith before the accident. I had lost, I'm sorry, Judge, just a little hard reading with the mask
Yes, sir.
fogging up a bit. I had lost my faith before the accident, but I brought it back afterwards and was confirmed to the Catholic Church soon thereafter. Along with my family, I will be carrying these two precious lives with me forever and wherever I go. I would also like to apologize to my friends and family for what I put them through, and I could never repay any of them for the support that I have received from them. I always pray for the Reisinger and Raubenolt families because your pain must be unconscionable. My life will be dedicated to repaying the cost of the lives that I took, and if given the chance, I will do everything in my power to prevent any fatal accident from ever occurring again. And that would be his statement.
All right, thank you.
Thank you, Judge. Judge, I'd like to recall Cheryl Herrin very, very briefly.
She's still under oath.
Mrs. Herrin, at the break you had mentioned there was something about the house sale that you wanted to correct the record.
Yes, I do. Thank you.
Yes.
The house was sold at a significant loss. The market value of the house was $1.1 million. We sold the house and agreed to sell it at a loss because we needed to get out from underneath the payments. And so by buying a home that was then, the market value was one half of, or almost one half of what we currently own, it brought our payments to, almost a third, 2/3 less.
This would be your monthly mortgage payment?
Yeah, monthly mortgage payment.
Okay.
And that's what we were looking for, is how we, both of us retired. We need to be able to figure out a way to make it through.
Okay. Does that conclude what you want to tell the court?
Yes, sir.
Okay, thank you.
Mr. Hubbard, any follow-up on that?
No.
Thank you.
Dr. Michael Mayer, please.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth and whole truth and nothing but the truth?
Yes, I do.
Good morning, Dr. Mayor.
Morning. Your Honor, I know I'm going to get dry now.
Yes, sir. I'll be glad to give you some water.
Thank you, Your Honor.
Whenever you're ready, Mr.
Thank you, Judge. State your name for the record and spell it for the court reporter, please.
Michael Scott Mayer, M-A-H-E-R-M-D.
And Dr. Mayer, you are, well, tell us your professional credentials, what you're certified in.
Yes. I am a medical doctor licensed to practice medicine in the state of Florida. I have a board certification in psychiatry. I am formally board certified in forensic psychiatry. I have been engaged in the active practice of psychiatry in the Tampa community for approximately 40 years. I have served on various committees and was a assistant professor at the University of South Florida College of Medicine for many years. I have been engaged in the practice of treating adults and children in my office. I have also been engaged in the criminal justice system from various different points of view at different times, and qualified to testify in court on many occasions. I work with families and children regarding mental health issues, and with the court system regarding criminal and civil, as well as dependency, which means child abuse matters in the state of Florida.
Do you know Cameron Herrin?
I do.
And has he been a patient of yours?
He has.
Would you first tell us, when did you first see Cameron Herrin in your office?
I first saw him following this tragic accident in June of 2018. He was distressed, and his family was overwhelmed. I believe he actually got my name through you, his attorney. I agreed to see him for an evaluation and then agreed to see him as a patient.
Since that day in, I guess it would be May or June of 2018, is that correct?
Yes, June.
A short time after the accident.
Yes.
Is that correct? How many times have you met with Cameron Herrin?
I've met with him in person in my office between approximately 30 to 40 times. I have also spoken with him on the phone, and his family members probably another at least 30 to 40 times.
So keeping it kind of general for a few moments here, was Cameron in some distress when you first met with him?
He was in extreme distress. He was not out of touch with reality, but his ability to be rationally and logically connected to his surroundings and his circumstances was weak and failing.
Did you find it necessary to prescribe medications?
I did.
What medications did you prescribe, and what was the diagnosis that resulted in those prescriptions?
The initial diagnosis was an acute stress syndrome related to what he described to me as I killed 2 people, and his terror and horror at thinking that he had done such a thing and that he was responsible for such a thing. He was prescribed antidepressant and anti-anxiety medications in order to allow him to sleep and maintain reasonable, logical connection with reality.
And from the beginning, did he accept responsibility for what he did?
He did indeed. I noted today in the testimony, and I've heard this before, that he called his mother and said, I killed 2 people. I'm familiar with these circumstances from 40 years of experience and training, and it is noteworthy that he didn't say there was an accident. He didn't say people died. He didn't say I'm in trouble. He didn't say the police are here. He said to his mother, I killed 2 people. Right from the very start, he took responsibility, and my experience and information indicates he has always and completely accepted responsibility. That is the first step on the road to genuine remorse.
So if you would you take us through the different meetings in your office and how things progressed during the course of your treatment, kind of a 30,000-foot view?
Sure. Maybe a 5,000-foot view, if you will. Within a few weeks, I became less concerned that he was going to completely disconnect with reality and require hospitalization. He stabilized a bit. That was partly related to his return to his faith, his belief in God, his understanding that God forgives. He might never be able to forgive himself, but God forgives. He didn't believe that God would forgive him, but he believed that God does forgive. In the initial weeks of treatment, he had the illogical, disconnected fantasy that he could somehow trade his life for these two people he killed. He knew cognitively, intellectually, that that wouldn't happen, but he repeatedly returned to that theme in his interactions with me. I noted in the testimony today that one of his friends said something about trading his life. I had never heard that before from someone else, but I heard it from him repeatedly in the first weeks of his treatment. He knew that that couldn't happen. He knew that if he killed himself, that wouldn't bring anybody back and it would make things worse, but he was preoccupied with fixing this, with turning the clock back, with doing something magical that would change things, and was absolutely committed to doing anything that he could possibly do. I worked with him to help him understand that it wasn't an either-or thing. It wasn't bring these people back to life or give up on life, that there was something in between. There was some hope to move forward, to stay alive, to work, to be a part of his family, to face up to the charges and accept responsibility that had value. That was very difficult for him because he saw it as an all or nothing thing. This was the extent of the remorse and the depth of the remorse that I saw in him in the first several weeks of treatment. As that continued, he did get better, and he started thinking about other issues and other aspects of this, always returning to the same theme of what could he do to make things better. Better for his family, better for the victim's family, better for the community, better for anybody and everybody. He improved to some extent. He was not disconnected with reality anymore. I think that was related partly to the medications, but more to his efforts and his family's efforts to face up to and accept responsibility and do what they could to deal with these circumstances. He was not very, as time went on, he was not very involved in the financial settlements that were ultimately made, but he was very supportive of his mother. He made repeated statements to her in my presence that he would do anything to make up for what they had lost, that he would devote his life to making up for what they lost, and he would take care of them in their retirement if he could, if he had to. Again, a renewal of his, the manifestation of his acceptance of responsibility and remorse. He, as I say, was not involved in the details of that, but was fully supportive of it. He also said to me, I saw him frequently alone and with his mother. He said to me alone, not with his mother, that he didn't want anybody to misunderstand what he thought about the money. And as I think about this, I recall he's crying and sobbing, boo-hoo crying and sobbing, saying that I don't want anybody to misunderstand me, but the money can't bring anybody back. The money can't undo this. The money, it matters, but it doesn't matter. He demonstrated a maturity and wisdom which is well beyond his baseline level in recognizing that nothing was ever going to make up for this. He told me in this context that he knew God forgives, but he doesn't think he will ever get to heaven, because no matter what he does, what he did was and is unforgivable.
Now, what I would like to do, I think the easiest way is to review the sentencing memorandum that we have filed and focus specifically on some of the departure grounds. You have had an opportunity to review the memorandum.
I have.
Okay. So the first ground that set forth, departure ground number 1, the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. Focusing on the last first, remorse. You've addressed that in your testimony thus far. Is there any doubt in your mind at any point has Cameron Herrin been anything other than remorseful?
No, not at all, never. He's always been remorseful. I don't want to be repetitive, but I'm sure I will refer to other incidents because it was constant, his expression of remorse.
All right. Now, in terms of sophistication, how sophisticated is this young man?
He's in some ways he's a bright kid. That's the way a teacher would describe him. But he's sheltered. He's not particularly sophisticated. He's not worldly, if you will. I shouldn't say that he's not worldly. He is worldly now. He was not worldly before this happened. In terms of his psychological development, he was a very innocent, naive senior at high school who hadn't had much experience in the real world with real life. That's not the case anymore, not by any means. He has learned horribly and dramatically by his experience. But before this accident, he was a kind of a naive kid.
And I should have prefaced this by referring to departure ground number 2. At the time of the offense, the defendant was too young to appreciate the consequences of the offense. So the answer that you gave, I guess, his age, what factors would factor into a defendant being too young to appreciate, and specifically here, Cameron Herrin?
Certainly the issue of his chronological age is important, 18 and a half. Some kids, some boys who are 18 and a half are more mature than others in terms of their social maturity and those sorts of social decisions. Some are less mature. As I've said, I believe he was a bit less mature than average, in spite of his good performance in high school and so on. In spite of his intellectual development, his social development was a little bit lagging. And his capacity, as is the case with so many teenagers, to recognize and be aware of the influences of his surroundings. A bright, happy morning with a friend on the way to the gym, and you push on the accelerator of your car, and it feels good, and there's no thought or awareness whatsoever that what you're doing is horribly dangerous. Even when there's excessive speed, not just routine speeding on Bayshore, which was the common social circumstance at that time on that road.
So how would that tie in to this prong of departure ground number 2, too young to appreciate the consequences of the offense? Are you speaking about, as you were just describing, consequences of his act?
Yes. His act was pushing on the accelerator and driving that car at an excessive rate of speed, at an extremely excessive rate of speed, without the cause and effect connection between one part of his brain and another part of his brain that says, doing this is really dangerous. All kinds of bad things could happen. medical science and the U.S. Supreme Court has recognized that the connection of the brain that makes a connection between cause and effect doesn't develop in young men until the early 20s. This is why we have the common sense social understanding that we hear all the time of how could he do something so stupid? He's a bright kid. It is because the stop and think part of the brain, the frontal lobe, where we stop and think about our action, is not developed in young adolescent boys, men of his age and circumstances.
And we will be addressing that in a little more detail later on, and but that is a relevant point to departure ground number 2. Departure ground number 3, we contend that Cameron Herrin poses no future threat to society. And doctor, based on all of the time that you spent with Cameron Herrin, do you believe, well, does he pose any future threat to society? And please explain.
I absolutely believe that he does not. And I was in the courtroom today and heard the testimony. I would add to what I've heard that not only does he not, from a lack of intent and a desire to be good to creatures, whether they be human beings or raccoons, he also has a terrible and powerful understanding of how lack of awareness, neglect, carelessness, lack of commitment to stop and think can lead to horrible, dangerous things. And he is much less likely than most kids, most teenagers, the vast majority of teenagers, to engage in dangerous activity that might hurt someone in the future.
So it appears that you have no doubt that he is not a future threat to society.
That is correct.
Now, departure ground number 4 will involve more legal issues and other issues, so we will not inquire there. Departure ground number 5 is the defendant may be sentenced as a youthful offender. And just briefly, you're aware of the statutory qualifications to be designated by the court and sentenced by the court under the Youthful Offender Act. Is that correct?
Yes, I am.
And what impact or what do you think that would be a satisfactory resolution?
What I can say about that is the following. Certainly, chronological age, it is my understanding that he meets criteria. In terms of psychological and social development and age, it is also my opinion that he meets that criteria. It is my understanding that the youthful offender process is one that recognizes that young adults are different than older, fully developed, mature adults, that when they commit a crime, they still must be punished, but there is opportunity for rehabilitation, and what I would also describe here in the same words that former Judge Holder described, an opportunity for what we can think of as restorative justice in the youthful offender program and strategies. And from that point of view, and I could say more about the restorative justice issue, the youthful offender type of program and concept very much applies to him.
And we will be talking about restorative justice here shortly. Ground number 6, relating to the monetary payment, that would not involve you. So now we move to the adolescent brain, and you've described a little bit of that already. And I think leading into it, it's kind of as you indicated, it's when the average person looks at something like this, as they do a lot of times with kids, how could the kid have done that? How could this 18-year-old do something so stupid, so consequential. What in the world were they thinking? And what I'd like to have you do is start out, because I think a lot of people say, this is just junk science, a bunch of guys in a room with little else to do but look at it and come up with these reasons. But would you start out and tell us the difference between the adolescent brain and an adult brain, and why this is accepted not only by neuroscientists, but the United States Supreme Court in a series of decisions and courts all over the country, that it is a true, legitimate concept?
Yes, and not to belabor the point or overdo it, but the science related to brain development goes back hundreds of years. We know, and common sense tells us without any doubt, that a newborn has a different brain than a 2-year-old, and a 2-year-old has a different brain than a 6-year-old. And the scientific literature and understanding of this going back decades and decades is unquestionable. We know that a kid before a child, a young adult, a child, before puberty has a different brain, different physical connections in the brain than they do after puberty. In the last 30 to 40 years, it has been possible through technology to really begin to study and understand how the middle and older adolescent brain, 15 to 19 years old, versus the young adult brain, 20, 22, 25 years old, is physically and functionally different. And there is overwhelming scientific evidence, as you referenced, some presented to the U.S. Supreme Court, which it has acted on in recognition of that scientific evidence, that there is a different functional capacity of the brain going from older adolescents, 15 to 19, to young adult, 22 or so. It is also relevant, and the science is very clear, that on average, boys are about 2 years behind girls in terms of this development. Now, this is something our teachers and some parents and people who work with children have been telling us for decades and decades. A 14-year-old girl is more mature, on average, than a 14-year-old boy. They just grow up a little faster. When they're talking about that, they're usually, not always, but usually not talking about academic intelligence. They're not talking about how the child performs on an IQ test. They're talking about social development, emotional development. They're talking about development and judgment in the areas of stop and think about what you're doing and what the consequences will be. This is where the adolescent brain of boys develops more slowly than the adolescent brain of girls. So this adolescent brain issue is deeply and relevantly connected to understanding why this kid, who by every other point of view is a fine human being, could be responsible for such a horrific act as speeding the way he did on Bayshore and killing 2 lovely, wonderful human beings.
Now, the terms we've set forth in the sentencing memorandum, we've addressed one of the United States Supreme Court cases that addresses adolescents and juveniles and things like that. And Justice Kagan, in the opinion, used terms such as immaturity, recklessness, impetuosity, heedless risk-taking as criteria or factors that are demonstrated by the adolescent brain. There are some behaviors that seem to be, again, as the Justice has indicated, somewhat characteristic of the adolescent brain in young males. Is that correct?
Yes.
And would you explain how this if you can, in terms of reckless conduct and unthinking conduct and just doing stupid stuff.
Yes, and one of the things that's important here is to really look at the environment. If you're talking about a kid who lives in an environment where there are drugs dealt and there are lots of guns around, then that 14-year-old might pick up a gun and be involved in a gun shooting and be criminally charged. And that's often what happens in the criminal justice system. There's another category, though, and that is the category that we have here, where there isn't any bad intent, there isn't a gun available, but horribly, tragically, there is a vehicle available that he didn't have the capacity to recognize the dangerousness of his driving that car. His mother takes responsibility for that. Of course, he also takes responsibility for that. The social circumstance is related to how the adolescent brain responds to those situations. And his social circumstance was that everything was okay. And he had this vehicle that he didn't know was more than he could handle. He didn't know that this was beyond his ability. And he pushes on the accelerator, and 2 people die.
So as we try to explain to the court here at the sentencing, you know, the overall question of why. Is one answer indeed the adolescent brain to explain how this occurred?
Absolutely. And it is horribly and tragically the case, and this also relates to the issue of restorative justice, that but for the grace of God go I. What I mean by that is that any teenager in his circumstances could have exchanged places with him, and the big picture would have been no different. There is an element of pure, random, horrible chance in this, not individual culpability or bad intent.
And is there something, I think, in the law where the law recognizes the differences, say, between somebody under 18 or somebody under 21 with specific statutes and things like that?
Yes, indeed, our society and our laws recognize that 18-year-olds have certain privileges and responsibilities and opportunities, and particularly, most notably in our drinking laws, the society says in effect to 18 to 21-year-olds, you're not old enough and mature enough to handle drinking, you're not allowed to drink. Now,
You have addressed or mentioned several times restorative justice, and that is a term that we hear with more and more frequency. Mr. Warren, the state attorney here, is a strong proponent in a number of public forums in support of restorative justice. What is restorative justice?
restorative justice is an evolving concept of the criminal justice system that recognizes that crimes occur, people need to be held responsible for them, they need to be punished for them, and in addition to that, we as a society need to find ways to restore the damage done, to restore justice. So restorative justice requires essentially two prerequisites. The first, that the defendant, this young man, take responsibility for his negligent criminal acts, which from the very first seconds after this happened, he has shown. You must take responsibility for it. You can't move forward without that. And you must be willing to try to do something to make up for it. Assuming that a person meets those criteria, then there are three pillars of restorative justice. The first is repair. If there's any way to make the situation better, to fix the window that you broke by throwing a rock through it, then you repair the damage. Obviously, in this case, there isn't. Although I would add, in his fantasy, in his disconnection from reality, he imagined that he could trade his life for the lives of these two people and repair the damage. So it's not possible, but the intent and the desire was there to do it. The second pillar of restorative justice is engagement. Is the person willing to engage with the people that they hurt, with society, with their community? Are they willing to look somebody in the eye and take responsibility and engage with them? Unfortunately, that hasn't happened here. The criminal justice system doesn't particularly promote it. Various other circumstances don't promote it. And the people he might engage with must absolutely be respected and not be expected to engage with him in any way that they choose not to. So that didn't happen. But the third pillar has happened and can happen, and it is my opinion that it has great benefit, and that is transformation. Transformation of the defendant, him, in terms of changing his behavior, his attitude, his relationship with society, and transformation of society so that while the repair of the particular damage in this case can't be completed, society can be changed in ways that addresses the issue. He has already begun working on doing things to address the issue of motor vehicle and pedestrian safety. He hasn't done a lot, he hasn't accomplished a lot, he hasn't had a lot of opportunity to do it, but he's done it. And I would add, he has not done it at my lead. He has brought this to me. I'm familiar with restorative justice as a professional and an expert in a greater way than he is. But these basic concepts he has brought to me, and I have helped him understand. I've thrown the ball back to him and said, if you want to do this, go ahead and do it. He's done things to move this process forward. It is my opinion, overall, that if he is given the opportunity in a non-incarceration sentence to address the issues of restorative justice, whether it means full-time work for decades, he has the capacity, his family has the capacity, the community has the capacity to do that in a way that will save lives.
Dr. Mayor, let me just take a look at my notes for a moment. And that concludes everything I have, and thank you very much.
Thank you. Any cross-examination?
Yeah, just briefly. Dr. Mayor, in your time spent with Mr. Herrin, did you do any type of physical testing, like a brain scan, CAT scan, anything like that, to determine how his brain has been developed at the age that he began meeting with you?
No.
Did you give him any type of cognitive testing, IQ testing, anything like that in your time spent with him?
No.
So you don't even know what his IQ is?
No, I absolutely know what his IQ is. His IQ is average to above average normal. That's based on his academic development. And that's a much better indicator of IQ than an isolated IQ test.
But don't you come in here and testify all the time about clients that you have that you've given IQ testing to, and you present that to the court to determine where that person is cognitively?
I wouldn't agree with that statement, no. In this case, his IQ is not an issue. He's a bright kid. That's everything we need to know. There doesn't need to be an IQ test to prove something which is already absolutely obvious. He's a bright kid.
And you don't think that that factors in, the fact that he's a bright kid, if he had a high IQ, that doesn't factor into his capacity to understand driving 102 miles an hour down Bayshore Boulevard prior to noon when there's a bunch of pedestrians around?
It absolutely is relevant, and I've said it's relevant. He's a bright kid.
But you still testify here that he still lacked the capacity to understand the danger that he was creating prior to the crash.
Yes, and that's not based on anything that an IQ test has the present capacity to reveal.
And it's not based on any type of brain scan or anything that you can point to physically to say that you know for sure that his brain is not developed. You're basing that all off of literature and other things that you have studied as a psychologist, correct?
I'm basing it on an understanding of science and medicine. I don't have to do a brain scan on a 2-year-old to know that that 2-year-old has a 2-year-old brain. It's just silly. I don't need to do a brain scan on him to know that he has an 18-year-old brain.
But he was 18, he wasn't 2, right? He was 18 when he committed the crime, right?
Absolutely.
Okay. But again, so you based it all on literature. Nothing that you've studied of his physical person or anything like that that would lead you to give the opinion that he failed to have the capacity to understand the dangerous situation he created prior to the crash, right?
No, I based it on the fact that he's 18 years old. I haven't
So you're lumping
suggested,
him-
excuse me, can I answer?
Sure.
I haven't suggested in any way at all that I made a specific, detailed assessment of his brain functioning. I know things about how an 18-year-old brains function. The testimony that we heard today here is absolutely consistent with all of the information that I gathered upon which I reached my conclusion. Doing a brain scan might give us an opportunity to put up pretty pictures and say, this is how the brain works, these are the colors, this is what goes on. That's not the point here. The point here is the testimony that we've heard, the information I gathered with him with many hours of work. This is not, if you will, from the legal point of view, a brain scan case. Your question just is not relevant.
Okay. Thank you for that. I'll leave that up to the judge to determine what's relevant. But you can answer my question.
That's my opinion.
So you're going to lump him in with every other 18-year-old that's out there based on what you know and based on your reading of literature and your training and experience, right?
No, absolutely not. He's
Let's-
an individual, and all of the things that I've just referenced are related to him as an individual.
So tell me what individually about this person tells us that he lacks the capacity, other than the fact that he was 18 years old.
All of the things that we've heard in court today. That
No.
That
Tell
his
me-
character.
You had to
May
know-
I finish?
You had to know
May I
things before
finish?
you came into court today, didn't you?
Pardon me?
You had to know things before you came in here to court today, right? To formulate an opinion?
Absolutely.
So I want to know what, prior to hearing today, what did you learn about this individual that allows you to give that opinion?
All of the things that I have heard confirmed here in court today. Those things are related to his character, his pattern of behavior, his social interactions with other people, his willingness to put other people's interests before his interest, his concern and empathy for creatures, human beings and raccoons, his ability to gather and interact with a social network that finds him to be valuable and useful, his willingness to trade his life, as he told me and as he told a friend, for the victims in this case. All of these things are part of his unique character that are the basis of my opinion. I could go through the list more extensively.
No, the point I'm making is that everything that you learned was all through your ears, right? Through hearsay, through things you heard other people say, things that you heard him tell you after he committed the crime, right? That's all I'm getting at. You didn't base it on anything physical, like something that you could put up a picture of his brain and say, hey, look, everybody, his brain's underdeveloped and this is why. You didn't do any of that, right?
That was a very complex question. Do you think maybe you could make it a little clearer to
Doc,
me?
did you rely on anything other than what you heard?
Yes.
What?
What I saw,
What did you see?
I saw him cry in my office.
Okay,
I saw
that's
other
talking
people
about
cry
remorse.
in my office.
I'm focused
I
more
saw
on the
pictures
capacity.
of the accident scene.
I'm focused more on the capacity.
I will do my best to answer a clear question. I don't understand the question.
I think it's pretty simple, but my question is, do you agree that everything that you're testifying to formulate an opinion on capacity is based on things that were told to you? and based on other things that you've read in books and studied.
And seen with my own eyes.
Okay?
Is it based on my perceptions? Yes, it's
Okay.
based on my perceptions.
Okay. You talked about the age, of drinking, but we all know the age to get a license, the trusted age is 16, right?
Yes,
So somebody, apparently smarter than everybody else, has made the decision that at 16, those individuals have the capacity to operate a motor vehicle, correct?
you know, I don't want to be argumentative with you, but you just asked me a question that suggests that the people who give 16-year-olds driver's license are smarter than everybody else.
That wasn't my
And
question.
this is a case that illustrates that that, in fact, might not be true.
Exactly.
So of course I'm not
I'm
going to
not
agree with
asking
that.
you to agree if those people are smarter
Well, that was
than
part
us.
of your question.
You agree that in the state of Florida, the law says that at 16, you can obtain a driver's license?
I certainly agree with that.
Okay, so someone, not judging whether they're smarter than us, someone has made the decision that a 16-year-old has the relevant capacity to operate a motor vehicle. Do you agree with that?
I certainly agree with that.
And to obtain, you got a license, right, a driver's license?
Yes,
And did you obtain it when you were 16?
17.
Okay,
in
and
New
did you have
Jersey.
to take some type of a test in order to accomplish that?
Yes,
And did you have to become aware of the laws that say you can't go over this posted speed limit?
yes.
And did you ever have to take the driving class prior to that in order to obtain your driver's license?
I think I did in high school.
And do you recall during those classes them, I know I did, and showing photographs of accidents and telling people, don't speed, right? Do you remember any of that?
Sure, I remember you've got to follow the laws or you might lose your license.
Yeah, and as a citizen and as a person that's driven a car, you know why we have those laws, right? Because you drive fast and you crash and people die, right?
Yes,
And again, those are things that someone has decided that's okay as a 16-year-old to learn that stuff, obtain the license, and go out on your own and drive a car.
yes.
Now, you talked a little bit about the restorative justice. Are you aware that restorative justice isn't advocating that no one should go to prison, is it?
No,
In fact, there are restorative justice programs that are provided in prison, correct?
yes,
And the point of that is to, not to avoid the punishment, right?
that's correct.
It's to take the person that was accused and the victim and maybe at some time restore the broken relationship or to help them to cope with what they had gone through, correct?
Yes,
So you're not advocating that restorative justice would stand to mean that this Cameron Herrin shouldn't go to prison?
I'm not advocating a particular sentence.
Okay,
I don't believe that's my role.
I agree. I'll agree with you on that. That's all I have, Judge. Thank you.
Redirect?
No, Your Honor.
Thank you, John.
Thank you, Your Honor.
The attorney's approach?
Your Honor, that will conclude the witnesses that we will be calling.
Okay. Both of you approach just for a moment. We're going to be in recess until 1:30. We'll come back then, and at that time, the state of Florida can present any witnesses. Thank you, everyone.
Court's in recess until 1:30.
We just get sworn in and go up there, or? Yeah.
Court's in recess.
Okay.